My job is to be brief, like brief. So couple of housekeeping matters. One, hopefully all those who are here who are interested in continuing legal education credits, make sure you get one of these. Mary Keating from Phillips Lytle is the person who you've got to keep happy. There is a form to fill out. Also, within this booklet of life is a couple of excerpts of work done by former appellate division clerks, and I want to recognize them. Trichet.
Oh, Trichet.
You're right there. Raise the bear.
Hi.
Thank you. And Gabriella, thank you.
Oh, wow.
Yeah. Whoa, we have stories. If you want to comment during the period, let us know. We would like to know more about that. And also, I want to acknowledge, and I know we talked downstairs, but Art Bailey for the terrific making this a reality. So to Art Bailey, thank you.
Yeah.
I'm going to yield here in just 1 second, but I just want to thank the justices for making this a reality. This is historic on so many fronts. To Lenore and Mark, thank you, and all the staff. You just are incredibly well, efficient, and I felt secure because you have a significant security staff here as well. And I know they watch me every minute at all times, because if you haven't seen it, there's a spectacular exhibit that they brought down of Robert Jackson's actual application to become a member of the bar. It's the real deal, the live signature. It is it, and they are watching me very closely. And so if I happen to stage left while they're talking stage right, you'll know what I'm doing. Anyways, I'd like to turn it over now to our presiding justice, Gerald Whalen, and with many thanks.
Well, thank you very much. I'm here really to thank people for this wonderful day. You know, everybody's thanking us for being here, but this has really been, and I've been talking to my colleagues about the whole day and yesterday, and it has been an incredibly wonderful experience for us. And so the thanks come from us to you. This has been great. We've really enjoyed it, and we look forward to hopefully doing it again. I mean, we want to make sure we use this bench again at some point in the future, right?
All those in favor?
Yeah. This is fabulous. Greg, thank you. I know that this brainchild started with you and Judge Curran, and they happened to run into each other at a basketball game, and one thing led to another, and they started talking about doing this, and here we are. And so thank you for that. Tom Schmidt is the interim director of the Robert Jackson Center. I want to thank Tom and Marion Beckerrink. Really, this has been fabulous. Your staff here. Your staff at the center is really top-notch. They're terrific. And they have been nothing but accommodating for us and our staff, and it's been just delightful, a real delight. The bar associations that have helped sponsor both a dinner last night that we had and the CLE that's about to start includes, as I understand it, and we've got some representatives here, so I'd like them to come up and be recognized if they would. Jamestown Bar Association, we have Lori Beckerrink here. Is Lori here? If you come up here, Lori. Daryl Brodegam is here from the Northern Chautauqua County Bar. Daryl, thank you for coming here. We got the Cattaraugus County Bar represented by Jeff Black. Is Jeff here? Yep, great, wonderful. And the center, the Robert H. Jackson Center, Inns of Court, is represented here by Lori Tierfeld. Is Lori here? Oh, Lori, yes, of course, yeah. We can't do this. We can't be here. We can't do the CLE without the active participation of the bars and the Inns of Court that are here for us. We really appreciate them stepping up and assisting with this. We know it's, we can be a bit of a heavy lift, and so thank you very much for being willing to do that. We have a little gift for each one of the bars here from the court. And it's always a little uncomfortable to give as a gift a picture of yourself. But that's what we do. And so really, a round of applause, please. Thank you. Thank you, folks. I appreciate that. Yeah. The photo has a little indication that it's down here. It's a memory of this day, this sit, which is historic. And we hope you can find a place in your bar associations to hang it. So I think we're ready to get underway, Greg, with the CLE. So let's do that.
This is going to be a view from the bench. Obviously, they're well positioned, and they're going to talk about statewide practice rules and local practice rules. So with that.
Very good. I know, I hope everybody can hear me. Is that fair? Yeah? Okay, good. The view from the bench, I think we find that we get a pretty good response from this conversation because, you know, not a lot of people, you have interaction very often with trial court judges, and you get into their chambers, you talk to their law clerks, you talk to the judge in chambers, and you get to see in the courtroom what they do and how they do it, and it becomes pretty transparent. But, you know, with the appellate court, it's not so transparent. And it's not just the way one judge operates, it's the way the court as a whole operates, both in terms of the staff and in terms of the judges. And let me start with the staff. I'd be remiss if I don't start by talking about our court, by talking about especially two people that have been here, I think yesterday and today, and have done a lot of work to prepare for these 2 days. And that would be our clerk of the court, who we are incredibly proud of, Mark Bennett. Mark may have stepped out, but
Yeah. He must have known it was coming.
Mark is about as talented and gifted a professional as we could ever hope for on our court. And we are really blessed to have him as part of our court system. He keeps things running. And Lenora Beaverfoot is executive director, or executive assistant, excuse me, of the 4th Department, and she works in the office right next to mine, and she is intimately involved in just about every aspect of the court that is non-decision related. And so she's a real go-to person, and she's been a real delight to work with, and I think everybody really enjoys the work that she does. And so if we could, a little round of applause for Lenora who put this together. And I'm not going to dominate this conversation, and nor, trust me, do you want me to. I'm going to ask, and I've got promises from my colleagues that they will kind of jump in and kind of carry the ball on various topics. But a view from the bench, the one of the things, and I'll kind of get us started. With the appellate court, one of the things that you learn to do as an appellate judge versus a trial judge is you have to become comfortable with the idea that even though a case may have been assigned to you, and we'll talk about how that happens in a minute, but a case may have been assigned to you to do the initial report on for your colleagues on the bench, the decision that ultimately comes out of the bench, even if everybody agrees with your recommendation, is not your decision. It's not your mem. It's the court's mem. And that is really a transition that takes place from the trial bench to the appellate court. And you soon learn that things go more smoothly when you're open, respectful, and responsive to your colleagues in terms of their thoughts, their concerns, and you have free and open dialogue about cases. And I can tell you, in fact, we were just talking about this. I've been on the court now about 6 years. I know Justice Perodato has been on about 12 years. We have a level of collegiality on this court right now that I think is about as high as it's ever been. The judges on this panel here, and the judges, our colleagues from Syracuse and Rochester area, we get along famously. We spend a lot of time together. Maybe, sometimes Justice NeMoyer might say too much time together, But no, we do. We enjoy each other's company, and it's a very helpful process for us to make sure that we keep the court running, we keep getting decisions out. And so that's an important piece of what we do. But let me kind of hand this off so you're not listening to me, and maybe we can start talking about how we go about with the assignment of cases and how that starts. Do you want to start?
Yeah, sure, I'm happy to. So yeah, a little behind the curtain. What you saw today was, of course, the argument of one day's cases, about 20 cases, I think we heard. So cases, I'm not entirely sure how the cases are assigned. That's still a mystery, and I'm sure it's not going to be disclosed to you because it's never been disclosed to me in the 12 years I've been on the bench. But we, so for example, this is our October term. We get before we even get the briefs and the records in our chambers, we get an order of sitting. And that's determined by the presiding judge and the senior staff. And that is really just every day of the term. It outlines the panels that are going to be sitting on each day. And then the briefs and records arrive. And we know, you heard Justice Whalen, Presiding Justice Whalen indicate that we prepare reports. So each case is assigned to an individual judge to report. And our report, we prepare it internally. Our chamber, for example, there actually I might have had 5 cases to report today. Normally I have about 4, normally I have about 4 cases. 20% of the cases will be assigned to me to report on an individual day. And so my chambers, we prepare an outline of the record, an outline of the briefs. Basically, an outline of the contentions of the parties, and a précis of the record. And then we do an analysis of the legal issues that are raised, and we make a recommendation on whether we should affirm, reverse, or modify the judgment or order that is before us. That report is circulated to my colleagues well in advance of the oral arguments. After our report, and so while I'm preparing my reports, I'm also receiving reports from my colleagues. Before oral argument, if, for example, let's say I disagree with, either in whole or in part, with a report or recommendation of Justice Curran, our practice is to generally call that judge ahead of time, and then we also often circulate something we call a discussion note. It's really like an internal memo, basically saying, I respectfully disagree with Justice Curran's recommendation to affirm for this reason, et cetera, and we outline it. The good thing about that is that, number one, it alerts, if I get one of those from my colleagues, it alerts me to the fact that one of my colleagues has an issue with my case. It also is circulated to the rest of the panel, so it gets the rest of the panel thinking about whatever this particular issue is. So when you hear lawyers say that the Fourth Department bench is a hot bench, that's part of the reason why. We come into the case, well, you saw it today. We've read the briefs, we know what the issues are, and we're prepared to ask questions on whatever issues we may have. So one of those discussion notes might go out, and then there might be a volley of other discussion notes, all before the case is even argued. And sometimes that continues after argument. I can think of, so I tell you all of this because there's so much that you don't see. The lawyers will see the oral arguments, and then in a couple of weeks, you'll see the decision that comes out. So we may have exchanged, a couple hundred pages of internal reports and discussion notes, and in 2 weeks, we'll release a decision that's 3 pages long. So it gives you some idea of the amount of work that goes on behind the scenes, and I think that's important. And also from the lawyer's perspective, as an appellate advocate, if you see, like Justice Curran and I going back and forth on a case, it should be painfully obvious to you two that we might not agree on that case. So And we may be just using you as a backstop, you know? We may be using you, like I may be throwing you, Jeff Black, a complete softball of a question and hoping that you'll hit it out of the park. So don't always think that the questions that we're asking are intended to trick you or trap you. We may be using you I may be using you to convince one of my colleagues of my position. So recognize that as an appellate advocate. Okay, so then after the arguments, we go and we conference the cases. That's what we just did while we were hoovering our lunch. At least I was hoovering my lunch. So we conference the cases, and to the extent that we can, we vote them. We vote, you know, we go through the list of cases and we take a vote on what we should do. Then the proposed writings, the proposed memorandum decision is circulated to the full court, and we review those and approve them for release we have full court conferences during our term. So that's just a little behind the curtain.
But it's clear the full court is not voting on the
Right.
individual case.
No.
That vote is up to the panel.
Right.
But we want the other judges to see it and keep them abreast of what we're doing in case they say, yeah, that's really great, but none of you were on a panel last month and we went the other way.
Right.
Oh, that might be something we wish to know about.
Yeah.
But what's interesting to me is, I guess, thinking that, you know, there's some of us with different backgrounds. And so initially I thought, oh, well, you know, does this person get the complicated commercial one? Does this one get this? No, you get every fifth case on whatever day you're assigned based upon what your seniority is. So if you're the lowest person, you get case number 1, you get case number 6, case number 11. So I think that took me a while to grasp that we're not playing anybody's expertise. We're trying to develop a judge who is aware of every issue and every type of case. So that's sort of interesting that I thought there'd be more specialization.
Very good. John, you want to jump in?
Well, first of all, the example Justice Peridotto gave you couldn't happen. She'd never disagree with me. We're classmates from UB Law, class of '84, so of course not. You know, people ask you for bits of advice in this job, and for those of you that appeared before me at the trial bench when I was there for 12 years, it is a very different job here. You're one of 5. I will emphasize a couple points. Number 1 is the collegiality. It is a spectacular group of human beings. We have enormous respect for one another. We listen to each other. For example, today, after we leave here shortly, we're driving to Syracuse because Justice John Centra is receiving the highest award that can be awarded for the Onondaga Bar Association. So there are 11 judges on the panel, 3 from Syracuse, 5 from Buffalo, and 3 from Rochester. All of us will be there to honor him because that's the kind of collegiality we have. So today we leave here, drive to Syracuse, and then back to Buffalo tonight. So that's the collegiality. The second thing is I would think is appreciate the extent to which we are a court of error. I think there are some states that even call our level a court of error. So if you identify the error, we'll address it. If you don't, we almost certainly won't. Notice the almost certainly. But just make very sure that the points you raise in your brief are preserved and presented thoroughly. That's my 2 cents.
And if you do want to annoy the reporting judge, make about 11 or 12 points in your brief. Because as the reporting judge, I have to address each and every one of them for my colleagues who will be reading my report. And it's like, well, this one, you know, believe me, you're detracting from the ability of the court to focus. If you have 2 good arguments, take the 2. Don't think putting up 12 will somehow convince us that, wow, the court was wrong 12 ways. We might as well not even get into it. No, give us your best ones and understand that if you have 12 points, we have to address each one.
Justice Troutman?
Just about everything has been said. I will say one of the amazing things is going back and forth with discussions on cases and starting out one way and the case ending another way. The ability to be open, even if you're the reporting judge, and decide that, no, I'm not going that way. Or the opportunity to get your colleagues to switch and come your way, to see your view, as Justice Peredato pointed out. Oftentimes, you may not know it, but when you make those arguments, when we're pressing you to answer a specific question, like she said, there is a reason behind it. And when you are just bent on, well, this is what I've prepared and this is what I'm going to argue, then you may miss that opportunity. But yes, we are open. It is a fluid process. And I will say one thing about the court. People will say, okay, from June to September, the end of June till September, the court's down. We're never down. Those who may have close friends on the Fourth Department or some of the other appellate divisions in the state, you'll notice we always have reading material. We can go on vacation and have reading material because it's important to be informed members of the court because we are serving the public. We know that you put a lot of effort into the work that you submit to the court, and your clients deserve the attention that is necessary to get it right and to resolve their matters expeditiously.
If I could, we haven't mentioned our two-year program, which I always like to mention, and we have with us today, you've heard that kind of oohs and ahs up here when we saw Gabrielle up there and Trichet. But I also see Mike Flaherty here, who I think might have been in our two-year program. Were you, Mike?
98 to 92, and a year with Church of the
Yeah, yeah. Is there anybody else here in the house that went through our two-year program? Any hands up if you have? Well, yeah. Mark
The
Bennett,
clerk
yeah.
of the court.
Well, the two-year program, we are. I always like to brag a little bit about the lawyers that we hire. We have a two-year program, and it's very often it's lawyers that are either fresh out of law school or they have 1 or 2 years. It's not always the case, but that's a large majority of the lawyers that we hire. And we have this program where you get this locked-in contract for 2 years, and it is a fabulous, if you would, legal research and writing program that they're put through for 2 years, and it is an intense 2 years. We work them very hard. There's a lot of cases that come through our court, and the most complex cases, the biggest record cases, are cases that we will get what we refer to as PRs, or preliminary reports, and they'll come from the two-year lawyers. And they have, of course, working with them and mentoring them, are permanent staff lawyers who are really a terrific group of lawyers. In fact, what I have found, and I don't think anybody would disagree with me, what I found is people that have the toolkit to do this kind of work, this really kind of cloistered research and writing, get in a room with records, go through it, summarize them, analyze the issues that are brought up, and write a very well-written report. People that have those tools in a toolkit are hard to come by, but they find their way into appellate courts, such as ours. And so what we do is we take these wonderful lawyers, and then we also will go through these classes, and we'll highlight the best of the best out of those classes. And we've been able to, and they like this work. And so they go out, they leave us after the 2 years, and then what we've been able to do is kind of bring some of them back when we have an opening for our permanent staff. And so the very best of the best come back, I find, and we have them working for us. And they mentor and help the two-year lawyers with their research and writing training that they do as they're doing the work for the court. And so what we get, and we have John Holt, who is now the chief attorney in our legal research department. And John is a really brilliant guy. And so they do these preliminary reports for us. on the complex cases. And so it's great training for them. It's wonderful for us because what they're doing, a big part of what I really enjoy is they summarize the record and they get us to places in the record which are really important for the issues that we're drilling down on. And so I find that to be incredibly helpful myself. And then they also take a really hard run at the issues that are presented to us, and then that comes to us, not in all cases, but when it comes to us in a case, we have that right off the bat. We then will write, if you're assigned a case with a PR, our chambers is then responsible for writing our own chambers report. And we may agree or disagree with the PR that comes to us, but everybody on the panel will get a copy of the PR, everybody on the panel will get a copy of the chambers report. And I find it really interesting when you have a disagreement between those two writings, because that really does kind of focus very often the issues and drills down on what it is that we need to be looking at on that case. So we're really gifted to have wonderful lawyers who have been with us, and they keep joining us. We also have with us, it's getting dark in here.
What was that all about?
I think it might be telling me my time is up. Yeah, that was Lenore. Ah, very good. So,
Oh, really?
yeah.
Oh, my
So
gosh.
I'd also, I would be remiss if I didn't do two things, though. One, I want to introduce, everybody knows him, no introduction necessary, but a colleague of ours that we just are thrilled that he's here today, Sal Martocci, Judge Martocci. I had the pleasure of sitting on the court as a brand-new associate judge, and I think I was with Sal on the court for maybe a year or two. He was just getting ready to get off as I was getting on. I don't think he left because I joined the court. But man,
Menza.
yeah. But I tell people, when I first got on the court, people would say to me, well, tell me about the Fourth Department. Tell me about the experience. What is it? Is it a liberal court? Is it a conservative court? What kind of court is it? I said, it's Italian court. And we have Judge Martocci, Judge Peredato, Judge Joseph, Judge Carney, Judge Sentra. I said, and we would go out because when we sit in, our terms are about 6 weeks. So 4 weeks we're in chambers, in our home chambers, and then 2 weeks we all gather in Rochester. And we arrive there either Sunday or Monday. We're there for the week. We go home for the weekend. We come back Sunday or Monday. We're there for the week. So when we're all down in Rochester, the non-Rochester judges, meaning the Syracuse judges and the Buffalo judges, we go out to dinner. And so that was kind of a new thing for me, and going out with a bunch of judges every night at your work, because you get through the end of the day, and it's okay, where are we going to dinner? And Sal was in charge of that when I first started the court, because he was able to pick these really great restaurants, but they were all Italian restaurants.
And we share our food.
Yes.
How weird is that?
Yeah. We eat family style as a tradition, pretty much, and so we pass around plates, and it's wonderful. But I gained a freshman 15 that I can't lose, and I blame Sal for it mostly. But anyway, Sal, really, it's wonderful to have you here. Thank you. The other thing I wanted to point out before I hand it over to somebody else on the panel is with regrets. It's already been told to you, we have to drive to Syracuse, so we can't stick around. We do have to get up and go and take off. I'm not sure what our timing is, Mark. We got about 5 minutes. And so I apologize in advance for not being able. I would love very much to be able to stick around and mingle and chat, but we just can't do it. We have to be on the road, and so please forgive us for exiting so quickly. We got about 5 minutes. Anybody?
Want to take questions?
Yeah, let's take some questions.
Let's do that. If there are any questions?
What?
Come on,
Oh,
there
a
has to
shy
be
group of
some.
lawyers.
Here we go.
Okay.
Just in terms of percentage, how important is oral argument? You go through all the process behind the scenes you told us about. Is oral argument like 8% of the decision, 2%, 27%, just roughly?
You want to take that?
And then secondly,
Yeah.
what causes a decision sometimes to be held over term from
Oh.
the decision release date? Is that often because the justices are disagreeing on the scene and they're working it through? Or can it just be that it got caught up in the final editing and writing process? Those are my two questions. Thank you.
Okay, so first with respect to oral argument, the one thing you should never forget as an appellate advocate, that one of your main roles is to answer the questions of the judges. You heard me talking earlier, if there's a disagreement and, I'm thinking, okay, well, I'm going to ask the lawyer this, I'm going to ask the lawyer this, or I'm going to ask the appellant this when they show up. If they don't show up, you've lost that opportunity to help me clarify whatever issue was bothering me. So I can't really give you a percentage of cases in which my kind of original view of a case has been affected, but I will tell you that that it definitely happens. I mean, there's, I can give you an example. I don't know if it was on, I sat on Tuesday and I sat last week, so I can't remember which one of these days, but I know that I had a particular case and I was kind of on the fence on it. I had a question mark. After our oral argument, I knew exactly where I was going, and it was because of the oral argument. So it does, and there have, I can tell you for certain that there have been a number of instances where I have completely flipped my position because of the oral argument. So it definitely happens. Oral argument, you should almost never really give up the opportunity to at least appear. And I know, particularly going to Rochester from Chautauqua County, I know it's a hike. And I know, because I've been in your seat. I argued before the Appellate Division a number of times when I was in practice. And I know how much work, how many hours it takes to prepare for a 5-minute oral argument or a 10-minute oral argument. It's insane. So don't think that is lost on this group. Okay, and your second question was?
The writings.
Oh, yeah, the writings, if the cases are held. It really depends. Sometimes it is because there's going to be more than one writing. There's going to be a majority opinion, or a majority member, a majority opinion and a dissent. Sometimes, particularly later in our calendar year, like if we're getting to May, sometimes it's just a question of the writings being backed up because the writings go through. We have kind of an editing department, so they're all submitted for editing and review. There is a process that our writings go through. So sometimes it's not because there's any sort of disagreement. Sometimes it's just backed up. But we really do make every effort. We make a huge effort to get our writings out quickly after the term.
I never understand why people look at us and say, well, what purpose does oral argument serve? It sounds like you've already made your mind up. You say, well, sure. Is there some important thing you've left out of your brief? There's something you're going to say at oral argument that wasn't included in your brief? We've read the brief, we know the facts, we've looked at the cases. So it's a rare case that we wouldn't have decided. But you have the right to steer us. But the one thing that I now understand is by showing up at oral argument, you are making it clear that you're not just relying on the reporting judge. It makes a difference to a lot of us when people show up. It's like, otherwise, I have the report. That's it. I'm going off that in the briefs. You show up and you highlight, and perhaps my colleague who wrote the report didn't really appreciate the significance of that. And you're sort of looking at them like, well, where was that? I want to know. So it is I think it's wrong to neglect and not go. It sort of means, oh, they didn't even want to bother showing. How important can this be? I don't think it's ever wrong to point it out to us, but as Judge Perodato says, please answer the question. You want to go through your argument and but we only care about one or two things. Answer it and then we don't care.
Something else that I think might be helpful with respect to oral argument that I think can be powerful medicine. And that is when you step up, if you know your case as well as most of you do when you come, to not, and we had this just happen, I just had this happen on a panel the other day, where the lawyer dug in on a weak point. And what it did is it completely took, he didn't need the point to win the case for his client. But it was in his brief, he was asked questions about it, he dug in, got deeper, and then finally somebody said, you don't really need that point. And yeah, that's right, I don't. It's really powerful, I think, for lawyers to get up and be so confident in their case to be able to say, look, this is my argument, and I'm not conceding the argument. However, I would like to address point 1 or point 3 and move off of it if you don't feel overly confident and you don't want the panel focused on that point.
I think the time is up, and though they are unable to meet and greet, I'd like to have us welcome them and thank them for all they've done. Please give them a hand.
Thank you.